Good afternoon, Doctor. My name is Li Ling, and today I'll be presenting about this distinguish between the legal capacity required in making a will from declaring a trust. First, legal capacity operates as a threshold requirement, ensuring that individuals possess sufficiently understanding to making legal effective disposition of property. In succession and wealth management law, an important distinction exists between the capacity required to make a valid will and the capacity to require to declare an inter rivals trust. A will is defined under Section 2, subsection 1 of the Wills Act 1959 as a declaration intended to take effect after death. Unlike trust, will remains irrevocable during the testator's lifetime and only operates upon death. Malaysian law also imposes a minimum formal requirements. Under Section 4 of the Will Act 1959, a person below Majority Act cannot make a valid will, while Section 2 of Age of Majority Act 1971 established that 18 as the age of majority. However, beyond these formal requirements, the law adopts different standards of mental capacity for wills and trusts. This distinction reflects that broader concerns about autonomy, protection, and the level of risk legal generated by each of the transaction. So the modern law of testimony capacity is anchored in Banks versus Goodfellow, requiring that the testator understands that the nature and effect of making a will, the extent of their property, the claims of potential beneficiary is not affected by any order of mind that distorts the decision making. This case established that a valid testimony capacity requires first, a testator understands that the nature of act and its effects. Second, understands that the extent of the property of which he is disposing. Third, to able to comprehend and appreciate the claims to which he ought to give effect. Fourth, no disorder of mind shall poison his effect, prorogue that his sense or right of prevent the exercise of nature of faculty. Fifth, no insane delusional shall influence his will in imposing of his property, and bring about the disposition of in which mind has been sound would not have been met. So this test is consistently interpreted as a functional test specific threshold rather than a global assessment of cognition competence. This focus is not abstract rationally or financial of historication, but also whether the testator can engage meaningfully of the core elements of the testimony in act. In this sense, a doctrine reflects a deliberate calibration standard of succession capacity designed and preserve the validity unless the clear cognification is impaired and established. The jurisdiction logic of this threshold is grounded on the jurisdictional nature of wills as an arbitrary instrument which only takes effect upon death. As so, no immediate proprietary reallocation occurs in the point of the execution. The law is not required to manage the contemporaneous risk or ongoing transactional consequences. This temporal structure allows the doctrine of prioritized testimonial freedom and also autonomous autonomy, even in cases involving partial cognitive impairment. The legal response is therefore not simply descriptive of cognitive ability, but also prescriptive of acceptance risk exposure in proprietary decision making. This relatively permisses the threshold also reflect within the statutory framework governing wills. So Section 3 of the Will Act 1959 required the testator be of sound mind, when Section 2 of Probate and Administration Act 1959 provides the interpretive guidance concerning testimony competence. However, the statutory framework doesn't only displace the common law principles established in Banks versus Goodfellow. Rather, the legislation operates alongside the common law in preserving a functional approach towards testimony understanding. Importantly, irrational alone is not just conclusive in evidence of incapacity, demonstrating that the law tolerates imperfect reasoning so long as the testator restrains sufficient, comprehensive, and also the testimony act. The arbitrary nature of wills further explains comparatively low thresholds for a testimony capacity. A will remains revocable throughout the testator's lifetime is legally ineffectively until death. Consequently, the execution of a will does not itself alter extension proprietary relationship during the testator's life. This significantly reduces the level of immediate legal risk generated by the transaction and justifies the law stronger emphasis upon testimony freedom. As probate law recognizes a will may be amended, revocated, or also replaced in any time priority of the death, continuing with control restraint of the testator over disposition of property. However, the assessment of testimony capacity is not purely mechanistic. Empirical and clinical literature demonstrate that courts often adopt a pragmatic and also context-sensitive approach, frequently relying on holistic judgment and also whether the will appears in coherence and rational in light of the testator's circumstances. This enforces that the will of the testimony capacity is shaped not only in cognitive thresholds but also underlying normative commitment and also autonomy respect of individual moral agency. Next, we'll be talking about the capacity of declaring a trust. So by contrast, capacity to declare a trust is assessed through a transactional specific framework, functional framework as in articulated in Manmaster, Lister versus Burton and Personier. However, the key is inquiry whether the individual can understand the nature of effect of the particular transaction in question. This approach is further refined in Re Barney, which introduced a proprietary principle. The more the significant the disposition, the higher level of the understanding is required. The doctrine structures reflect fundamental in different jurisdiction character of trust, which operates inter rivals and also generates immediate legal consequences. First, trust involved in immediate proprietary allocation as the effect of separation of a legal and equitable ownership during the settler's lifetime. This is a real-time re-extraction of a property distinguished trust from the testimony instrument which remains the legal inert until death. Second, trust generates ongoing fiduciary obligations imposing reinforceable duties, regulate conduct over time. This introduces relational supervisory legal framework that is absent in wills and significantly increase the legal complexity of the transaction. Third, trusts often carry commercial, tax, and also structural consequences, particularly in modern wealth management contexts. These consequences extended beyond like private donation intended and also may affect third-party actors, and also institution arrangement, thereby increasing a systematically importance of ensuring trustworthy understanding. Accordingly, trust capacity is more demanding because it is concerned by its merely intention to dispose of property, but within the comprehension of a legal architect that also operates immediately and also continuously after creations. While some scholars must support this position by emphasizing the capacity standards are instrument sensitive, but also varying the risk of according to the risk profile, complexity, and also maybe the legal consequences and the transaction of the question. This justifies differences threshold rather than a uniform standards of the cognitive ability. The Malaysian trust law further demonstration stricter approach in the SK MV Persekutuan Sendirian Berhad versus Pembinian Legenda Unggul Sendirian Berhad. The federal court reconfirmed that the segregator necessary before a trust is over retention sum can validity. The court rejected the proposition that a trust could actually exist under that unsegregatory funds because the certainty of subject matters requires clear identicality of the proprietary constitution the trust assets. This reflects that the equity border inconsistency that proprietary obligations cannot arise in the absence of the sufficient certainty and also the enforceability. The lower the threshold for testimony capacity is best understood as a deliberate legal choice to prioritize testimony and freedom and also autonomous autonomy. The rule in Bang versus Goodfellow established that a functional test is requiring only that the testator understands the nature of the extent of property and the claim of potential beneficiary. This is not a requirement in the optimal reasoning of rational decision making, but also rather that a minimum threshold of comprehension sufficient to validate personal autonomy. So modern scholars emphasize that this reflects a normative commitment to allowing individuals to control distribution of their estates even in circumstances in partial cognitive impairment. The law therefore tolerates imperfectional decision making in order to preserve the principle of individuals should remain free and to determine how their propriety is distributed after death. So this justification of the premises approach resets on three interlocking rationalities. First, the absence of immediate proprietary consequences is a will is arbitrary and only takes effect upon death, such as no living proprietary interests are altered at the time of execution. Second, to reduce risk of a third-party harm, because no immediate transfer occurs and also the risk of prejudice to third parties during the testator's lifetime is also minimal. Third, respect for moral agency. The law treats the testimony disposable as an extension of personal identity and also moral autonomy, justifying that a different approach to capacity. So patient instrument also emphasized that this structure reflects a legal preference for respecting last wishes even if cognitive vulnerable individuals, provided that a minimal comprehension is present. So we're talking about by contrast, the capacity is required to create an intervirus is significantly more demanding because trust operates in the presence and also generates immediate legal consequences. Court therefore adopts that as transaction-specific and also contextual standards as articulated in Masterman Lister versus Bruton and Co., where capacity depends on individuals' ability to understand the specific transaction in the question. So this is reinforced by Ria-Barney, which introduced a sliding scale. The more significant the differs, the higher quality of understanding is required. So this actually reflects a shift away from status between capacity towards functional capacity, as such which legal competence is so tied up to the nature of the transaction rather than individual's general mental condition. The heightening transfer by trust is justified by the interrelated considerations. First, the immediate proprietary reallocations. Unlike will, trust operates inter rivals and also therefore immediately alters property relations. The creation of a trust can actually separate legal and equitable ownership in states, producing real-time changes in proprietary structures. Second, the creation of fiduciary obligations. Trust imposes that reinforceable fiduciary duties on trustees, requiring the complement with strict equitable obligations. They have duties and also may have long-term complex, particularly when discretionary trusts are involved. Thirdly, irreversibility and also complexity. Once established, managed trusts are also difficult to revoke or alter, particularly when the third party or maybe the tax consequences are engaged. The complexity of the trust instrument justify a higher threshold of understanding. Fourth, the third party realignment and also transaction certainty. Trusts often function between the border beneficiary and also commercial system. Beneficiary and also external party may rely on the validity of the trust structure. So Forfeit and also Radford conceptualize this as an instrumental specific capacity, arguing that different legal acts and also impose different cognitive demands, therefore require for a different threshold of understanding. So the support of ideas is a uniform capacity standard would actually be conceptual inappropriate given for the diversity of legal consequences. While speaking of the risk of calibratory and also legal certainty, a deeper justification for the divergence lies that the idea of the capacity mind operates from a risk-based legal calibration. So Barr's theory of standards of proof actually provides a useful analogy. The more serious the consequences of the legal determination, the higher level of certainty required before the law actually intervenes. So applied to the capacity, the wills actually involves in polygamous and also non-reversible effects, but no immediate transactional description, while in other hand, trust actually involve in presence and also ongoing proprietary consequences, increasing the immediate risk and also legal risk. So this explains why the law requires greater certainty of understanding in trust formation and also the potential for immediate and also irreversible legal consequences necessity as a higher threshold of cognitive comprehension. So, speaking of intermediate criteria evaluation, so despite its doctrine cohesion, the distinction between testimony and also trust capacity has been subjected to some academic criticism. So the central concern is actually between the distinction is actually increasing the difficulty to justify in modern estate planning, practicing and involving understanding also of the decision making of the capacity. So the distinction between will and trust, increasing risk collapsing formalism, insofar that the legal category rather than the substance decision determines the applicable capacity thresholds. So a major challenge arises from the functional convergence of the trust of the wills and also the inter-rivals trust. So in modern practice, trusts are actually frequently used as substitute for wills, particularly through revocable trust, discretionary family trust, and also a plural will arrangement. So some scholars also demonstrate that this cognition is not new. Inter-rivals trust has been used to archive testimony objectives while avoiding probate. As a result, a formal distinction between the lifetime and post-dispositional offense fails to reflect substance legal reality. So Parma also argues that the use of inter-rivals trust for testimony proposed to create a hybrid category of estate planning that blurs doctrine boundaries. So this raises a critical question. If two instruments are kept substantially similar to distribute outcomes, is it conceptual to justify to apply rather the different capacity thresholds? So the current doctrine structure is actually very heavily instrumental based, well, meaning that the legal consequences depend on a transaction classified as a will or a trust rather than on the substance of the decision while being made. So Whitman crisis about the approach, arguing that capacity will should be instead function-based, focusing on whether the individual understand of the consequences of the transaction rather than the formal legal categories fall into which falls. So on this view, actually, the distinction introduced arbitrariness by attracting different standards to functionize similarly to decisions. So this low justification for a lower threshold in testimony capacity is also weakened by increasing the recognition that testimony blue freedom is not absolute. Legislative and also judicial development have introduced protective mechanism allowing courts to intervene where testimony decisions are made under vulnerable and or maybe incapability. So Harding's analysis statutory here demonstrate that courts actually authorize the wills on behalf of individual lacking capacity applying to a best interest framework than fundamentally protective other than autonomy basis. This represents a shift away from a classicatory testimony freedom towards a more intervival model. So further criticism arises from inherent instability of capacity demonstration. Empirical and also doctrinal scholarship highlights that the capacity assessment are actually contents dependent and also interpretive and also heavily reliant on the judicial and also expert evaluation. Pursuant argues that capacity is actually better understood as a continuum of decision-making ability rather than a binary legal status. Similarly, has also emphasized that capacity rules reflects underlying normative values rather than objective cognition thresholds. So the distinction between testimony and trust and capacity is actually doctrine coherent in the principle, resting on meaningful and also difference in timing, legal effects, and also risk exposure. So the trust involved in immediate proprietary consequences and also fiduciary obligations, justifying a higher threshold of understanding. Wills, by contrast, operates that bottomlessly and also therefore justifying a permissive standards grounded in autonomy. However, this distinction is increasingly unstable in practice. The rise of trust also will be the will substitute also erosional in absolute testimony freedom, and also the recognition of capacity as a continuum and also collective undermining and conceptual clarification of the divide. Accordingly, the distinction is best understood as a parameter mechanism for calibrating legal risks and also rather than a rigid doctrinal separation. So in conclusion, the distinction between testimony capacity and the capacity required to create an intervival trust is at a formal doctrinal level intelligible because it reflects really different in legal effects. Will are arbitrary and also operates only on death, whereas trust operates immediately and generally ongoing proprietary and also fiduciary consequences. On this basis, a defensible that the law is applied at a lower autonomy concentration and also threshold for wills under the Bank versus Goodfellow, which applying a stricter transaction sensitive and also standard of to trust. However, the continued coherence of this distinction increase open to the question. So modern estate planning frequently use trust as a functional substitution for testimony disposition and also contemporary understanding of capacity, emphasizing contextual spectrum-based evaluation rather than rigid category thresholds. The more convincing position is therefore distinction should be retained, but also understand a pragmatic legal calibration tool rather than a contextual absolute divide. It remains justified and in functional terms, but also theoretically clarified, increasing undermining the conversion of modern wealth transfer mechanism and also involving the understanding of capacity as context dependent. Ultimately, the distinction survives not because it reflects a deep concept divided into cognitive capacity, but also remains a legal convenient mechanism for distributing risk between autonomy, protection, and also lastly transcription certainty in private law. That's all for my presentation. Thank you.